Nasir Qadri Sahab. You have the floor. Advocate Nasir Qadri, you there?
Yes, thank you very much. Thank you, Wani Sahab. First of all, I'm grateful being a panelist, and that too, this is a very crucial issue. We have heard so far the theoretical side of this UPRs and India's positioning. But let me share some pragmatic side of the story, particularly about the India and the UPRs. If we look the first cycle in 2008, then second cycle in 2012, and the third cycle in 2017, and then now the recent cycle, which is, of course, 2022, the fourth cycle of UPRs. There were some recommendations, and the recommendations from the NHRC, recommendations from the stakeholders. There are some issues which are of the dire importance. Other panelists, they have already discussed that. But let me tell you, there are some heinous crime against humanity, which India has already been perpetrating in the northeastern side and, of course, in the occupied territory. And then there are so many observations from the Supreme Court as well. Supreme Court of India. Right from the first cycle, the torture, Convention Against Torture, there were so many recommendations. The National Human Rights Commission, they also recommended to India to ratify the Convention Against the Torture, because torture is one of the heinous atrocity crime, and it is, of course, a crime against the humanity. Not only the torture, India is willfully staying away from the ratifying the Convention on Enforced Disappearance. Now, India has willfully stayed away from these two important conventions because all India will be exposed of their crimes against humanity in occupied territory and in the northeastern side, where India is scooping the armed conflict against the Naxalites. If I share with you some of the judgments which were passed by the Indian Supreme Court, right from the Montedio versus State of Goa, it was about Indian judiciary vehemently failing to have the domestic legislation to stop the crimes against humanity. And then there is two important judgments. Please note and please analyze and see. It was Jagjeet Singh Arora and Navjot Sandhu, where the court, they were reluctant in passing any orders because of the non-compliance, because of not having the domestic legislation. In Sandhu's case, Navjot Sandhu's case, court showed the failure of courts to consider and appreciate the qualitative different kinds of the armed conflicts. Then Qadri Abbas Habib's case, again the failure, and the Salwa Judham case, where India vehemently failed to comply with the humanitarian law. I have seen the fourth UPR. There was, I really appreciate Altaf Hussain Wani Sahab, who has recommended India of ratifying the additional protocol 1977 of Geneva Convention. But before that, has India ever complied the Geneva Convention? Because they have the domestic legislation as the Geneva Convention Act of 1960. No, the court has passed the conjectures. The court has multiple times issued the judgments wherein they said that there was non-compliance of the humanitarian laws in India. There's one case, Salwa Judham's case, where the Indian government of India officially they raised the armed militias, which was already raised in Kashmir. Both armed militias disbanded the Supreme Court. And then, due to the non-compliance of this Geneva Convention, there was no prosecution. Now, not only this, the black laws, the draconian laws, already APSPA, Public Safety Act, and now this anti-terrorism law, so-called UAPA. There has been so much analysis on these Even the Supreme Court has heavily burdened the state on the APSPA, but there is non-compliance. APSPA black laws are already there. Public Safety Act, which is to satisfy the subject to satisfaction of the detaining authority. Who is he? A third-rate judicial magistrate who passed the orders without applying the proper mind, without complying the constitutional mandate and the mandate under the UDHR, ICCPR. It's there. Everything is there. Every black law is there. Now this UAPA, which is stringent, a black law, detaining a renowned human rights defender, Khurram Parvez. There was no cogent evidence against Khurram Parvez, but there's an act, which the act says that any person can be declared as terrorist. Now, not only this, students, we have a case of a doctorate student who is languishing in jail from last 1 year, Ala Fazli. There's no charges against him. He was cited in 2012. You wrote an article wherein you have challenged the so-called the sovereignty of India. India is no more a sovereign. India, if we analyze a practical on the pragmatic footing, keeping in view the judgments, the decrees passed by their own courts, the recommendations, the handicapness of the National Human Rights Commission, India, let us not shy away calling India as an apartheid state like the Israel. If Ukraine, if we see the issue of the Ukraine, the international community, they're just beating their chest out, calling that why Russia, why we cannot issue a kind of order, or why there can't be a suspension of the Russia over the Russia's so-called invasion. One failed to understand the double standard of the international community. When the judicial orders are there, when the crime against humanity is documented, recorded, torture is recorded in India, a persecution of minority Muslims, my dear brother from these minority Sikh community was here. He has given his own testimony about his brother. Why can't we call India's apartheid state? And you know, there is already a provision in Article 6 and Article 5 of the UN Charter, suspension. Let us push India to those, expose to the extreme, expose all these atrocities, crime, what India has been perpetuating. There is a worse situation, if you remember, if we go recall whatever happened in Cambodia and Africa, when the international community, when they tried to suspend, though it was not there, you have seen there is an unfortunate case. I see as a student of law, international law, these states they bully, particularly the superpowers. But there has always been a side of an oppressor because of the economic interest, because of so many other interests. But this is a time you see all these UPR cycles, the recommendations. India is perpetrating, India is involved in war crimes, crime against humanity, now these non-compliance of these important treaties. So there a time has come where these cases and a global community, particularly civil societies, I'm happy that this KIIR has invited so many intellectuals, so many activists from the different countries. A similar endeavor can be a physical endeavor to push for the tribunal, a criminal tribunal, where each of these atrocities, crimes, each of these non-complaints can be advocated. It can be discussed so that India should be held as an apartheid state. India is otherwise, their army is a rogue army because they are involved in heinous crimes. Khurram Parvez, a human rights defender, has already exposed India of perpetrating the torture. They have named some officers who were the alleged perpetrators, who have committed the rape. 8,000 documented cases of the info disappearance are there. The courts are failing. Courts are run by RSS Sanghi, these the elevation of the Supreme Court and the High Court, particularly in the occupied territory. they all have the background of these RSS terrorists. So this is the time, come out of this framework, this framework go. I disagree with the earlier panelists that we should not just focus. An occupying state who is occupying a territory, he has also the responsibility towards the occupants, the occupying. So India as an occupier has to fulfill the obligations because there are already laws of the occupation. Apart from let this process go, but there is always an alternative under the international law. I'll not take much time. This is another topic which would be discussed, how and what are the remedies under this international law to have the separate thing against this apartheid state. I thank you very much.